Welcome to the Willfulation Guide to Probate.
Let's start with the basics. The term probate actually refers to the process of proving a will's validity and in turn an executor's authority to act. However, it is commonly used to describe the entire estate administration process. There are two types of personal representative: executors and administrators. An executor is the person responsible for disposing of the testator's property in accordance with the terms of the will. An administrator, much like an executor, is responsible for winding up the deceased estate and distributing the assets in accordance with the rules of intestacy. A grant of representation is a general term used to describe the document which confirms the personal representative's authority to act. The capacity in which you intend to act will determine which grant you will apply for. An executor derives his or her power from the will itself. The grant of probate provides proof of the will's validity and in turn proof of the executor's power to act. A testator can choose to have as many executors as he or she wants, but only 4 can apply for a grant of probate at any one time. Those who are not granted probate have power in reserve, which means they can apply for a grant at a later date in the event that an acting executor is removed or steps down. Administrators derive their power to act from the letters of administration. As a result, they are not permitted to meddle with the estate until they have obtained the grant. This can make safeguarding the estate difficult, as there are limitations on what an administrator can do with the property before the grant is obtained. Up to 4 administrators can apply for the grant at any one time. The Non-Contentious Probate Rules 1987 sets out the order of priority to apply for grants of letters of administration. The order of entitlement mirrors the order of entitlement to inherit under the rules of intestacy. An applicant must clear off all those with a better entitlement before he or she can obtain a grant of letters of administration. If the will does not appoint an executor, or the appointed executor is incapable or unwilling to act, a grant of letters of administration with the will annexed must be applied for instead of a grant of probate. The non-contentious probate rules also set out the entitlement to the grant of letters of administration with the will annexed. Once again, each applicant must demonstrate that they have the best title to receive the grant, as potential applicants higher up in the list will be given first refusal if they are willing and fit to act. Personal representatives act in a fiduciary capacity, which means that they are under a legal and moral obligation to act in good faith and in the best interests of the estate and its beneficiaries. This duty is important because an executor's power places them in a position of great trust and responsibility, so it is essential that that power is not abused and the estate is administered fairly. A personal representative could become personally liable up to the value of the estate if he or she fails to act in a reasonably competent manner. In a nutshell, estate administration can be broken down into 4 steps. If you're an executor, you can resign or renounce your right to a grant of probate by signing a form of renunciation. Although the document takes effect immediately, it will not be legally binding until it is lodged with the probate registry. Once it has been lodged, you will not be able to retract it without the permission of the court. Only an executor who has not interfered with the estate can renounce his or her position or refuse to obtain probate. This is known as intermeddling and indicates that you have accepted the position of executor. In the case of administrators, you can allow someone else to apply for the grant of letters of administration instead. This includes someone with a lesser entitlement. This type of property automatically passes outside of the estate to the surviving owner. The deceased share of the property will still need to be added to the estate's inheritance tax calculation. Property that has been written into trust can pass to the beneficiary without the need for a grant because it passes outside of the deceased's estate. The property is under the control of trustees who have a fiduciary duty to administer the trust in accordance with the terms of the trust instrument. Examples of property that are commonly placed in trust include life insurance policies, money, and real property. Trusts can also be used to avoid probate costs and mitigate inheritance tax liability. Some small estates can gain exemption under the Administration of Estates Small Payments Act of 1965. Generally, if the estate is valued less than £5,000 and comprises mainly of money held in a bank or building society, a personal representative will only require a written request to release the assets, which should be accompanied by a copy of the will, if any, and the death certificate.
Some organisations may even release up to £15,000 if requested.
In the case of intestacy, the organisation may also require you to indemnify them against future claims. An organisation is entitled to insist that you produce a grant to prove your authority to receive the asset if they wish. Personal representatives can be held personally liable for losses incurred by the estate and its beneficiaries if they fail to act with reasonable care and skill. Acts that may incur liability which result in a reduction in the value of the estate include, but are not limited to, bad investments, failure to secure and insure the assets of the estate, failure to properly discharge debts and liabilities, disposing of assets without the knowledge or consent of the beneficiaries, failure to carry out duties and transactions in a prompt and timely manner, any other acts which constitute a breach of a fiduciary duty as a personal representative of the deceased estate. As a personal representative, you owe a duty of care not only to the creditors and beneficiaries that you are aware of, but also to unknown creditors and beneficiaries too. This makes things a little tricky, but it is possible to mitigate your liability by carrying out the following steps.
Place Section 27 advertisements in the London Gazette and newspapers local to where the deceased lived, owned property and carried out business. Give any unknown creditors or beneficiaries at least 2 months to respond to the advertisements and make a claim against the estate. You might also want to request an indemnity from any known beneficiaries so that you are protected should an unknown creditor or beneficiary bring a claim at a later date. Under the Inheritance Provision for Family Independence Act 1975, a disgruntled party can bring a claim against the estate within 6 months of the issue of the grant of representation. Section 44 of the Administration of Estates Act 1925 gives the personal representative a year's grace to distribute the assets of the estate. However, care should be taken to ensure that the exercise of this right does not result in loss to the estate or its beneficiaries. A claim can still be brought against the beneficiary after expiration of the 6-month limitation period. The court will expect all parties to act in a reasonable and non-confrontational manner. You may want to consider mediation before involving the court in a dispute. Of course, there are times where mediation is not possible or suitable, but every effort should be made to resolve any issues amicably. Failure to act reasonably may lead to a party being penalised. An executor is highly likely to be held personally liable if he or she is found to be litigating frivolously and without good reason. If you believe that there might be a conflict of interest, you should seek independent advice from a qualified professional to determine what you should do next. This table represents suggested guidance for solicitors' fees. Solicitors are entitled to charge an hourly rate in addition to these fees, so it is a good idea to negotiate a fixed fee from the outset wherever possible. Alternatives to using a solicitor include prepaid packages. These packages cap administration fees to around 1% of the value of the estate in exchange for an upfront payment. Our prepaid package includes any will, a power of attorney, free lifetime storage, and a 1% cap on estate administration fees. The emergence of probate companies has made the market far more competitive, which puts consumers in a better position to negotiate fees. Remember, cheaper does not always mean better. It is important to choose a regulated provider who is experienced and knows what they are doing. We provide probate services in conjunction with two of the best service providers in the market. If you would like further information on our probate services, please feel free to email us at info@willvolution.co.uk. Alternatively, you can send us your query via our contact page at www.willvolution.net. If you would like free independent probate advice, you can also contact the Probate and Inheritance Tax Helpline on 0845 30 20 900. For online assistance, you can also visit the Citizens Advice Bureau's website. We hope that you have found this presentation useful. Thank you for watching.